Right, if you want to, you can move that, off, but because, we can put that back over there. I had Patty move earlier that laptop. Oh, yeah, we can move it back over here, so it's not right. You got it. That's good. All right, we are in session and on the record in cause number CR 21-371, State of Texas versus Casey Lynn Spriggs. I believe that we are set today on Mr. Spriggs' motion to suppress evidence. Is that correct, Mr. Ashmore? Are we ready to proceed? On the record, off the record.
Request off the record and needs to be on the record.
All right, council approach. All right, we're back on the record. Cause number CR 21-371, State of Texas versus Casey Lynn Spriggs. We were set today on Mr. Spriggs' contested motion to suppress. This time, the defense has requested to continue this case. Mr. Ashmore, do you want to give the record a brief synopsis of your request?
Yes, Judge, the defense makes the respectful request, which is to continue, which is not opposed by the state. We're appreciative of that. There's the sole issue is the voluntariness of the statement. The defense, and that's my error. Vacation brain, storm brain. I didn't bring a sponsored witness. I've asked the court and the state to grant this request for a short continuance on that issue, so we can have that sponsored witness. We do not anticipate this, both sides agree, this will be about an hour hearing. Could be a little longer than 20 minutes per side, a total of an hour. And we would request that be continued to June the 20th at 1:30 in the afternoon to facilitate the testimony of the sponsored witness regarding Mr. Spriggs' records that are attached to our motion. It's not in a missile format, just so that we can go forward on the merits of the hearing.
Ms. Curry, any response?
In order to check the record, Judge, we do not oppose the continuance.
All right. Court is going to grant the defendant's motion for continuance. The court's going to set this for a final hearing on the defendant's motion to suppress June 20th at 1:30. If we do not go forward that day, then the motion to suppress is going to be denied.
Yes, Judge. Too many lies. Too many lies. That better with Mr. Spriggs for moments.
Yes, you can do that.
Should we go in the hall?
Yeah,
Need other
Just
business?
head to the back of the courtroom and you can do that there.
Yes, sir.
I can see him, so I can see him. And I'll even smile at that. I'll smile.
All right, Mr. Schmidt, are you ready?
Yes, sir, I'm ready.
Are you ready on?
Ready on Zugan Toms. Come on down.
All right, Mr. Toms, if you'll come forward, this is cause number CR 22-158. State versus Dugan Lee Toms, motion to revoke. Go ahead, Mr. Schmidt.
Judge, as of probably a couple hours ago, we had an agreement with the state. The probation department has determined that they are not on board with that agreement. So we're gonna have to go back and revisit. We'd ask a reset on Mr. Toms.
Okay. All right, court sets Mr. Toms in for a final contested hearing on June 20th at 1:30.
Of course. Yeah. You ready? For the
Ready.
next?
Who's next?
Stephanie Goss. Yes,
Stephanie Lynn Goss, CR 2163. Is Ms. Goss a plea?
sir.
Let me see if I have her papers here. All right, Ms. Goss, if you will raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. Is your name Stephanie Lynn Goss?
Yes.
Ms. Goss, you appeared before the court previously on October 25th of 2022. You pled guilty to the felony offense of abandoning or endangering a child, a state jail felony. The court heard the evidence and the court accepted your plea agreement and the recommendation of the state. The court assessed your punishment at 2 years confinement in prison and then suspended that sentence and placed you on 2 years of community supervision. It was during that period of community supervision that the state filed its motion to revoke. And in that motion to revoke, they alleged what appears to be 6 separate counts of violations. Have you had enough time to review those allegations with your attorney, Mr. Schmidt?
Yes.
Are you pleased with Mr. Schmidt as your attorney?
Yes.
And everything that you've read and signed in your plea agreement today, did you do so because you understood what you were reading and signing?
Yes.
Do you have any questions before we go any further?
No.
Mr. Schmidt, do you believe Ms. Goss to be competent?
I do.
Does she waive the formal reading of the state's motion?
Yes, sir.
Does she intend to plead true to all 6 counts?
Yes, sir.
All right, Ms. Goss, I see that the plea agreement in your case is that you would be pleading true to all 6 counts, that the state's recommendation is for your community supervision to be revoked and your punishment to be assessed at 13 months confinement in state jail, with you paying the balance of your fines, court costs, and fees. Is that your understanding of the plea agreement?
Yes, sir.
Let's see, I'm looking for a judgment, Mr. Schmidt. What's her credit time? I don't think I have a judgment here.
100 days, Judge.
100 days exactly?
Yes, sir.
There it is. All right, Ms. Goss, if you'll tell me, how do you plead to counts 1, 2, 3, 4, 5, and 6 as alleged? Are those counts true or not true?
True.
And you're telling me that they're true because in fact, what is alleged is true, right?
Yes.
Ms. Goss, has anybody threatened, forced, or pressured you to plead true to any of these counts?
No, sir.
All right, court accepts the defendant's plea of true to each count as alleged. Mr. Schmidt, any objection to the evidence supporting the plea?
No objection.
All right, that is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing.
Anything further from the defense?
No, sir.
All right, then based on the evidence presented, the court finds that Stephanie Lynn Goss has violated the terms and conditions of her community supervision. The court follows the plea agreement and recommendation today. The court revokes Ms. Goss's community supervision, assesses her punishment at 13 months confinement in the Texas Department of Criminal Justice State Jail Division, orders her to pay the balance of her financial obligations. Court also awards Ms. Goss 100 days credit towards her sentence for the time that she's already spent in jail on this cause. Ms. Goss, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Please step over to be fingerprinted. Once you are released from TDC, Ms. Goss, hang on. I'm sorry. Once you are released from TDC, I need you to report to the courthouse in order to make arrangements to discharge your fines and court costs. If you don't do that, then a warrant is likely to issue for your arrest, okay?
Okay.
So it's important, once you get out, come up to the courthouse and make arrangements to pay, either pay them in full or pay them on a payment plan, okay?
Okay.
All right, thank you. You can step over now.
David,
Who's next, Mr. Schmidt?
David Dixon.
All right, let's see. On my docket, I've got Mr. Dixon with 2 cases, but he has multiple. He has more than that, doesn't he, Mr. Schmidt?
Yes, sir. We're prepared to resolve 4 cases.
Are the other ones just not said, or are they in another court?
No, I believe. Oh, you know what? I'm seeing a 2022 382. That's a misdemeanor motion to adjudicate. That's got the county court law. Then we have a CR 22 269, which is a motion to adjudicate, and then we have a original plea on CR 23 178 and a motion to dismiss on CR 23 177. I believe, I can't swear to it, I can't recall whether I filed a motion to transfer the misdemeanor back up, but it is a judgment adjudicated, I don't know.
All right, Mr. Dixon, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, you can lower your hand. All right, Mr. Dixon, you're here on multiple cases today. You're here on cause number CR 23 177, which is an assault of a family or household member by impeding breath. CR 23 178, which is a charge of possession of a controlled substance, state jail felony. CR 22 269, which is a felony charge of burglary of a building. And cause number 2022-382, which is a charge of a misdemeanor assault causes bodily injury. Do you feel like you've had enough time with Mr. Schmidt, your court-appointed attorney, to review all of these cases and have all of your legal questions answered?
I do.
And are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
Mr. Dixon, have you ever been diagnosed with any type of mental condition?
No, sir.
All right, Mr. Schmidt, do you believe Mr. Dixon to be competent to enter into these pleas? And if so, that he's doing so intentionally, knowingly, and voluntarily?
Yes, sir.
Does your client waive the formal reading of the state's motions to adjudicate in cause numbers CR 22-269 and 2022-382?
Yes, sir, we do.
And is he pleading true to all counts in both of those cases?
No, sir, in both cases, he's pleading true to all but count one. Count one would substantiate the motion to dismiss as well.
All right, so Mr. Dixon in cause number CR 22-269. You appeared before the court on January 5th, 2023. You pled guilty to burglary of a building. You reached a plea agreement with the state. And the state recommended that the court not convict you, but place you on deferred community supervision for 2 years and a $1,000 fine. The court followed your agreement, and during your period of community supervision, the state filed a motion to adjudicate. And in that motion, they have alleged what appears to be 11 separate counts of violations. On that same day, the court also heard evidence of a assault causes bodily injury, Class A misdemeanor. The court again heard the evidence, found enough evidence to convict you. However, the court followed the plea agreement and the recommendation of the state and placed you on deferred community supervision for 2 years. And during your period of supervision, the state also filed a motion to adjudicate in that case and has alleged what appears to be 9 separate counts of violations. I see the plea agreements in your cases here are that upon your plea of true to count 2 through the remaining 11 and count 2 through the remaining 9. As to the burglary charge, it appears to be that the state's recommending that you be adjudicated, convicted of burglary of a building, that your community supervision be revoked, that you be sentenced to 12 months confinement in state jail with the balance of your financial obligations, which are fines, court costs, reimbursement fees, and you would receive 362 days credit towards your sentence in that case. Is that your understanding of the plea agreement in that specific case?
Yes.
And in regards to the assault causes bodily injury, the state's recommending also that you be convicted of that offense, that your community supervision be revoked, and that you be sentenced to 305 days in the county jail, with you receiving credit for 305 days of time served towards your sentence. Is that your understanding of the plea agreement in that case?
Yes, sir.
Now, with regards to cause number CR 23-178, possession of a controlled substance in less than 1 gram, you're not on probation on that case. This appears to be an original offense, and the range of punishment for the state jail felony possession is not less than 6 months confinement or more than 2 years confinement in the state jail division of TDC, and a possible fine not to exceed $10,000. I see the plea agreement is that you would plead guilty to that. The state's recommending that you be convicted and sentenced to 12 months confinement in state jail, and the court ordering you to pay restitution of $180, court costs of $290, reimbursement fees of $20, and you would receive 304 days credit towards your sentence for the time that you've spent in jail on that case. Is that your understanding of the plea agreement there?
Yes, sir.
All right, so Mr. Dixon, at this time, with regards to the probation case, burglary of a building, how do you plead to counts 2 through 11? Are those counts true or not true?
True.
With regards to the assault causes bodily injury, the motion to adjudicate, how do you plead to counts 2 through 9?
True.
In With regard to the indictment for possession of a controlled substance, how do you plead to that offense? Guilty or not guilty?
Guilty.
Mr. Dixon, are you pleading true in your probation cases and pleading guilty in your original charge of possession today? Because what is alleged in the probation cases, those violations are true, and you're pleading guilty because in fact you did commit the crime that you're alleged to have committed. Is that true?
Yes.
And Mr. Dixon, has anybody threatened you, forced you, pressured you to plead true or guilty in this court here today?
No, sir.
All right, the court will accept Mr. Dixon's pleas of true in each of the probation cases respectively, and the court accepts his plea of guilt to cause number CR 23-178. Mr. Schmidt, any objection to the stipulation of evidence in the new case and any objection to the evidence supporting the revocations?
No objections.
All right, evidence is admitted in each one of those cases respectively, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? Anything further from the defense?
No, sir.
Okay. All right, then based on the evidence, the court finds that David Paul Dixon, having violated the terms and conditions of his community supervision, follows the plea agreement today, revokes his community supervision, adjudicates his guilt for burglary of a building, cause number CR 22-269, adjudicates his guilt of assault causes bodily injury, class A misdemeanor, and cause number 2022-382. The court, upon revoking community supervision, assesses punishment at 12 months confinement in the state jail division of TDC for the burglary of a building, orders him to pay the balance of his financial obligations, and awards him 362 days credit towards his sentence in that cause. In the assault causes bodily injury, court revokes community supervision, adjudicates his guilt of that offense, assesses punishment at 305 days confinement in the county jail, orders him to pay the balance of his financial obligations, and awards him 305 days credit towards his sentence for time already served. On CR 23-178, the court finds that there is sufficient evidence to convict Mr. Dixon of possession of a controlled substance. The court does convict him of that offense and assesses his punishment at 12 months confinement in the state jail division of TDC, orders him to pay $180 restitution, $290 court costs, and $20 in reimbursement fees. And the court awards Mr. Dixon 304 days credit towards his sentence for the time that he has spent in jail on that case. Is there a distinction on the 304 versus the 305 days? That's not a typo, is it? Is there a difference of 1 day between the misdemeanor and the new cause? Is there a 1 day difference on the credit time? I just want to make sure. It just seems odd that one's 304, one's 305. It could be that he was not served with a warrant until he was put in custody, but I'm assuming that this is what Ms. Abney is checked to be the accurate time.
Yes, sir. I would suspect that's the case. It's a delay in the service of the warrant. He was in custody on at the same time on those, so they probably should both be 305.
Can we have Ms. Abney check that, or State, do you know? All right, and the court is also granting the state's motion to dismiss and cause number CR 23-177.
Your Honor, according to Ms. Abney, the prison was 1 day less because his sentence starts the day of the plea, and we can't get jail credit. But he'll get credit for the day because that's the day of his sentence, but he doesn't get jail credit for the day. His jail credit stops yesterday.
Okay. Did you hear that, Mr. Schmidt?
No, sir, I sure did not.
Is your microphone on?
So, So he gets credit for today because that's the day he was sentenced for the prison case. And he had yesterday and previous 304 days. So once you count today, he has 305 days on that.
Oh, I see. Okay, because it's a county jail time. That makes sense.
Yeah, TDC will, I guess, they'll give him credit beginning tomorrow.
Yes.
Okay,
Gotcha.
thank you. Thank you, Ms. Abney. All right, then, Mr. Dixon, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. When you are released from TDC, you have fines and fees that you're going to need to pay. If those are not paid within the next year or until you get out of TDC, actually, you might not even be down there very long, if at all. So you're going to need to make arrangements to discharge these fines and fees or make a payment arrangement here at the district clerk's office in the courthouse. Failure to do so and to comply with the financial obligations will result in the court issuing a warrant for your arrest. Okay. So these are things that don't just go away. These are things that have to be tended to. You understand?
Yes, sir.
All right. All right. Step over to be fingerprinted on those 3 judgments. I think he's still, let's see, does he have more?
I believe that's all.
Mr. Schmidt,
Yes, sir.
I think Miss Curry wanted to have a word.
And I'm not sure how important this is, Judge, but one of the cases from this morning, Mr. Jason Williams.
I can't hear him.
Here, you can be seated because he can probably hear you better if you're talking. Yeah, he said if you're standing up, it's shooting over it. Yeah.
One of the cases which has been announced on this morning, Mr. Jason Williams, the court inquired as to what the plea offer had been. I think Mr. Schmidt told the court 40. Richard, my notes are that I had offered 25 the other day when you were in the office. Do you not, is that not what you know?
And I didn't hear that. I'm sorry.
Miss Curry said that with regards to Jason Williams, who we specially set for trial on, I guess it was Tuesday's docket, Wednesday. Was that Wednesday or?
Yeah, we did it on Wednesday too.
Yeah, we did on Wednesday. That the court had inquired as to what the offer was, and that you indicated that your recollection was that it was 40 years confinement in the Texas Department of Criminal Justice. Ms. Curry has indicated that she had a conversation with you in the office where she had extended an offer of 25 and just wanted to make sure that that's on the record.
I see. Well, and my recollection is we were tossing numbers around and that was a suggestion, but I don't recall it as an offer. And it wasn't an offer that I relayed to my client. I would have ultimately followed up with Ms. Curry on that, which I will do again to clarify, just to make sure we're all on the same page. But the last note I had was it was at 40. But I know that we had conversations that were ongoing. So
Okay.
I'm
And
not
so-
surprised by that.
Okay, and so Ms. Curry, is 25 an official offer that the DA's office is making to Mr. Williams for Mr. Schmidt to relay?
Yes,
Okay, anything
Cool.
else? Is it anything different than 25 on as charged?
No.
Okay.
Got
All
it.
right, if you'll just relay that to Mr. Williams and then let us know if that changes anything. Otherwise, we'll just continue to have him specially set for December.
Yes, sir. Thank you. I'm glad we cleared that up. I think that's all I have.
Yes, thank you, Mr. Schmidt.
Thank you.
Don't let me forget to have Mr. Austin's name called today in the docket. Mr. Abraham, does Mr. Manning need some time?
Judge, I'm ready on a couple.
Well, I mean, do you need time to wrap up more, or I don't want to interrupt you. I mean, we can do a couple now if you want, but if you're in the groove, I don't want to interrupt you.
Judge, Ms. Burns is looking at a couple things for me, so I can go ahead and knock out a few that are ready.
Okay, who do you want to call first?
If we start with Mr. Mays.
Jason Lee Mays, CR 2401. All right, is Mr. Mays going to enter a plea today?
He is, Judge.
All right, Mr. Mays, sir, if you'll raise your right hand, I'm going to place you under oath. Mr. Mays, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Judge.
Thank you, sir. You can lower your hand. All right, Mr. Mays. Let me go over some paperwork with you here. You appeared in the court on July 7th, 2022. You pled guilty to the third-degree felony offense of driving while intoxicated, third or more. The court heard the evidence and assessed the plea agreement, and at the recommendation of the state, the court assessed your punishment that day at 10 years confinement in prison and a $2,000 fine. The court then suspended that sentence and placed you on community supervision or probation for 5 years. During that period of probation, the state filed a motion to revoke, alleging violations, and it appears that they've alleged 6 separate violations. Have you had enough time to review those violations in that motion with your attorney, Mr. Manning?
Yes, Judge.
Are you pleased with the work that Mr. Manning's done for you?
Absolutely.
And where you have signed your paperwork today, Mr. Mays, is that your true and correct signature and you only signed once you were confident that you knew what you were signing?
Yes, Judge.
Mr. Manning, do you believe Mr. Mays to be competent?
I do, Judge.
And do you, does he waive the formal reading of his motion, and does he intend to plead true to all counts?
He does waive and he does intend to plead true to all counts.
All right, thank you. All right, Mr. Mays, I see that the plea agreement today is upon your plea of true, the state's recommending that the court revoke your community supervision, assess your punishment at 5 years confinement in prison, ordering you to pay your previously ordered fines of $2,000 plus court costs, reimbursement fees, and you would receive jail time credit of 484 days for the time that you've spent in jail on this cause already. Is that your understanding, Mr. Mays?
Yes, Judge.
All right, so Mr. Mays, how do you plead to the counts alleged in the motion? Are those counts true or not true?
True, Judge.
And you're telling me that what is alleged is true because in fact it is true, correct?
Yes, Judge.
Has anybody threatened, forced, or pressured you to plead true to any of these counts?
No, Judge.
All right, court accepts the defendant's pleas of true to counts 1 through 6 as alleged. Mr. Manning, any objection to the evidence supporting the plea?
No objection as offered for states 1.
All right, that is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from state?
Nothing further.
Anything further from the defense?
Nothing from defense, Judge.
All right, then based on Mr. Mays' pleas of true and the evidence, the court finds that Mr. Jason Lee Mays has violated the terms and conditions of his community supervision. The court imposes sentence today pursuant to the plea agreement, revokes his community supervision, assesses punishment at 5 years confinement in the Texas Department of Criminal Justice, orders Mr. Mays to pay the remaining balance on his financial obligations, and awards him 484 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Mays, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you do get out of prison, if you've not paid off the fines, court costs, and reimbursement fees, you need to report to the courthouse and talk to them about taking a payment plan or something to take care of those, okay? Your failure to do so may result in a warrant being issued, okay?
Yes, Judge.
All right, good luck to you, Mr. Mays.
Thank you.
Who do you want next, Mr. Manning?
Judge, next ready on Mr. Donica.
All right, Tyler Scott Donica, CR 21285. All right, did y'all get paperwork done on Mr. Donica?
We did, Judge. We have both the amendment as well as the state's motion to withdraw and continue. With that, there's a continuation to be on the mental health caseload. And also as a condition of probation, his back time credit of 105 days will be eaten up in this plea. Additionally, they've also amended for the attorney's fees of $500, and that's included in his court costs for continuing payment.
All right, and probation supportive of this plea?
Yes, Judge.
All right, Mr. Donica, sir, raise your right hand. I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can lower your hand. All right, Mr. Donica, you're represented in this case by your attorney, Mr. Manning. Are you pleased with Mr. Manning and the work he's done?
Yes, sir.
And you feel like you've had enough time to talk to him about the state's motion to revoke that was filed, and you understand the plea agreement that is being made between you and the state today. Is that correct?
Yes, sir.
Do you have any questions about anything before we go further?
No, sir.
All right, and you understand that if the court approves this withdrawal of the motion, and the court would modify and amend your community supervision to order you onto the mental health caseload, and that any jail time credit of the 105 days, should you later be revoked and sentenced, you would not get credit towards any subsequent sentence in this case. You do understand that?
Yes, sir.
And you also understand that you're going to be obligated to pay new court costs and attorney fee reimbursements.
Yes, sir.
All right, Mr. Donica, has anybody threatened, forced, or pressured you to enter into this agreement with the state here today?
Yes, sir.
All right, and Mr. Manning, you believe that Mr. Donica is entering into this agreement with competency, and he's doing so intentionally, knowingly, and voluntarily?
I do, Judge.
All right, then the court will grant the state's motion to withdraw. The court will continue Mr. Donica on community supervision, amending his conditions to include placement on the mental health caseload, and the court orders him to serve 105 days in jail as a condition of community supervision, and the court will issue him credit for that 105 days once it's served, if it's not already served. In addition, the court amends his community supervision conditions to include court costs and attorney fees. All right, thank you, Mr. Donica. Anyone else, or you need time, Mr. Manning?
Judge, if I may have just a little bit of time, I'd like to speak to Mr. Hartwell. I just spoke to Ms. Burns about one of the cases that says this afternoon that we may be able to get a resolution on. So if I just have a couple minutes, I'll reach out to Mr. Hartwell shortly.
Okay, and so I'm showing you have Miss Delaney and Miss Opera left. Is that correct?
As well as Ms. Simpson.
And Miss Simpson. Okay. All right. I will. How much time do you think you need? 15, 20 minutes?
15 minutes, Judge.
Okay. All right. Court's going to stand in recess for 20 minutes. Allow Mr. Manning to speak with his clients.
Thank you, Judge.
I don't have a motion.
Your Honor,
Okay, now I thought that was about that. This is what I owe, or this is what
okay, I'll text him.
I know. Right, okay. I was like, what? Okay. Joe, correct?
All right, sorry about that, Mr. Manning. I took up another issue in chambers while we were waiting. So sorry about that being a little longer than anticipated. Are you ready on your? file?
Yes, Judge, ready on Miss Simpson.
All right, Amber Michelle Simpson, CR 14369.
Oh, shoot.
She snuck up on you. All right, what are we doing on Miss Simpson?
Judge, we reached an agreement today for Miss Simpson's motion to be withdrawn. And she continued on supervision with the added condition of her being placed on the intensive supervised probation docket. Additionally, Judge, they also amended for finances. So her total financial obligations are going to be $5,094. And that first payment we made first day of June. I spoke to her about her living situation. She does have reliable transportation. Additionally, she has several places that she can stay, get her feet underneath her. And she also has a couple of job opportunities lined up that she hopes to take advantage of once she gets out.
Are we going to be able to avoid any future motions? Are we in a good position to not have any concerns about that going forward?
Judge, I believe so. Without going into too much detail, Ms. Simpson had a rough couple of months that resulted into someone very close to her dying. And I think that after 9 years of being sober, it just it kind of wrecked her life. She's dealt with some mental health issues as well as she's dealing with some other stuff outside the criminal justice system. And I think after talking to her, she fully understands the chance that this is, the responsibility that it is, as well as the fact that she's on notice that if she's unable to be successful, then she faces the full range of punishment when she comes back before this court.
All right, Ms. Simpson, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. And Mr. Manning, I'm assuming that probation has been consulted and they approve and want Ms. Simpson placed back into their custody?
Judge, that is correct. In speaking to Ms. Burns, we consulted everyone that needed to be consulted, and they are supportive of this plea based off of Ms. Simpson's taking responsibility for her actions and her missteps while she was on probation.
Okay. All right, Ms. Simpson, in this case, you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning and the work he's done?
Yes, sir.
You feel like you've had enough time to talk with him about your motion and that you've had all of your legal questions answered?
Yes, sir.
You understand the nature of the agreement today?
Yes, sir.
You understand that if the court grants the state's motion to withdraw and we amend your community supervision, that you're going to have additional obligations, additional financial obligations for new attorney fees, court costs. You're going to have additional obligation for intensive supervision, and that might be more strenuous than what you were facing before. You do understand that?
Yes, sir.
And are you making this agreement because this is what you want to do?
Yes, sir.
And
Absolutely.
has anybody threatened, forced, or pressured you to make this agreement?
No.
And you, Mr. Manning's been arguing on your behalf, everything that he said regarding your ability to comply in the future. Do you believe all of what he said to be true?
Yes.
And so are things going to be different for you going forward?
Yes.
Can you just briefly tell me how they're going to be different?
Like you said, I really went through a lot of things the last few months before I went to jail. Sorry. Honestly, after 8 years I've been on probation for almost the whole 10 years, you know, and I know where I mess up, and really it's people. My main goal is to get out of Anzac County and get away from out here. I know that's probably a lot of people's, but even my probation officer is Larry. Even he said like my best thing for me to do is to get out of here, which I was trying, and then everything happened to me all at once, and I decided that I would be okay if I just go hang out with certain people, and I'm just not okay. I do have the job lined up. I do have all of these things that I was working towards when my spouse died. And, that's when I went into the probation office. I did ask Larry for help, you know, it was a little too late. Obviously, I had already lost pretty much everything that I had worked so hard for. And, so I just, sorry. I want to get the help. I want to get the mental help. I want to get the counseling. Like I want to get my son back, you know, so.
And Judge, if I may, that was one thing I forgot to, no, you're fine, you're fine. One thing I forgot to point out also is she does have appointments that have already been ordered and set up for the Andrews Center. So that would be one of the things that's top of her list that we've talked about is getting that mental health treatment. She's not been receiving that here in the jail, and that has taken a toll on her emotionally and mentally. And so I think she understands what's laid before her. The question is if she chooses to do it. I think if the past 9 years has been any indication, she can do it if she is set her mind to it and she has the proper tools in place. And as you heard from her, she recognizes where her dangers are, her pitfalls are. I think I'm confident that she can conquer those.
Is she looking at expiring this
Next year,
next year?
next year, Judge.
Okay. Well, I guess when did she get on? She get on in 2015?
March 2015.
Okay. So that's not that long from now. So that's either a very short time in which to get through it, or it's a very short time in which to make up a lot of ground. So I'm not sure which one you're having to face, but I'm sorry that you've gone through some of your personal losses. I can understand how that could tempt you to do things to either, handle your own self-anxiety or things of stress. I understand that, but I always hear, and Mr. Gann's right. If there's certain groups that you can't be around, and the only way that you can not be around them is to move away, then yeah, you may have to do that. But I'll also tell you that I've lived in Van Zandt County my entire life, and I've never been tempted to do drugs or do any of those things. And it's not because those people aren't around. It's just because I don't choose to be around those people. If I went out looking for it or allowed myself to be around it, then yeah, I might have the same problems that you do. So location doesn't mean anything. It's an individual decision. It's an individual choice and action. So I know that it may be hard to remove yourself from if it's family or close friends, but if you don't remove yourself from those situations, you're going to find yourself in a situation you can't be removed from, and that's going to be locked down in prison. And if you're locked down in prison, you're not going to be getting your son back and making, these progressions that you need to in your life. Okay.
Yes, sir. Thank you.
All right, court, you're welcome. The court grants the state's motion to withdraw. The court will continue Miss Amber Simpson on community supervision. Court places her on the intensive supervision program and amends her financial obligations, including new attorney fees and court costs. All right, Miss Simpson, just get to work and finish
Yes,
out
sir.
the last, whatever you got, 7, 8, 9 months, and move on with your life in a positive direction.
Thank you.
You're welcome. Who's next, Mr. Manning?
Judge, you ready? Next, ready for Mr. Pry.
All right, this is cause number CR 22-280, State versus Miranda Jill Opry. Motion to revoke. Go ahead, Mr. Manning.
Judge, I was provided with a offer by the state. I conveyed that to Ms. O'Brien today. I provided that offer to Ms. O'Brien today. She was liking some time to consider that offer, as well as see if there any additional mitigation evidence would help assist in the negotiations. My recommendation is we set her for contested docket on the June 20th date. And if we're unable to reach something before this point in time, that we go ahead and have it contested on that date.
Any objection from the state?
No.
All right, the court will grant that request, Mr. Manning. I'll set this for final hearing on June 20th. So if we don't have a resolution We either gotta go forward, with the motion that day, or it must be withdrawn.
Yes, Judge, and I've explained that to my client, and she's understanding of that. Yes. Thank you. Judge, if I may just have a moment, we have a last minute agreement with Ms. Delaney and probation department and the state. If I can just have just a second to go over what that is, entails, and have her sign off, we'll be ready to go.
Okay, I'll give you a few minutes.
That's what anybody go on.
Yeah.
Judge, we were ready.
All right, this is cause number CR 20-399, State versus Lindy Cherie Cheney. On motion to revoke, go ahead, Mr. Manning.
Yes, Judge, Ms. Delaney, um, through conditions of her probation had some difficulty with methamphetamines. It was offered today that she be amended and do safe P as a condition of probation, and so she has agreed to that. They've amended her finances to include the $500 reimbursement fee, and this will be continued. She will not need to be extended due to the length of time she has remaining.
All right, Ms. Delaney, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. So why are you crying?
Because I came in here, I guess, with different expectations is all.
So what are the tears for?
I have a lot going on and, with my family, and I'm not gonna be there for it, so I'm kind of sad about that.
Understand. Okay. Ms. Delaney, in this case, you're represented by Mr. Manning as your attorney. Are you pleased with the work he's done?
Yes,
You feel like you've had enough time to talk with him about your case, that you understand all of your rights?
yes,
And are you making this agreement today because this is your decision to accept the offer from the state?
yes,
And you understand, if I approve this, that you will remain in custody until you are sent to the Safe P program. You understand that?
yes, sir.
And you'll also have the new financial obligations, including attorney fees and court costs. You understand that? All right. And Miss Delaney, before I approve this, are you wanting to go to rehab and try to change your life?
I mean, yes, I do. I mean, I know where my issue was. It's getting back around certain people, and I mean, I went and I made sure that that wouldn't happen, so I moved, and I even moved out of county. That way, when I got out, I wouldn't have to go back around those same people. And it's just, I did a lot to make sure that when I got out, that it would be better, and like I said, I just came here today with different expectations, that's all. So, my heart's still broke.
But if you go to SafeP, you understand that SafeP is an educational facility. That's what that's what treatment is about. They don't give you drugs to offset your desire for other drugs. What they try to do is change the way you think, change the way that you act, and rehabilitate you by making sure that you're sober while they're trying to change the way that you think and act and make decisions. So
Yes.
you understand that this is not a magic pill, that this actually requires effort, work, and determination. Do you understand that?
Yes, I do.
And I'll tell you, Ms. Delaney, people that go down there that don't understand that and they're not willing to accept that, they don't do well. They get kicked out of the program. They come back and they end up in prison. But people that do go down there and they understand that and they learn as much as they can and they actually apply what they learn to their lives when they get back, although it's going to still be hard, it's not going to, like I said, it's not a magic pill, doesn't make it easy.
Right.
But those people are going to have a much greater chance of staying sober and staying out of custody.
Right.
I've seen it really work for people, but the only way that it works for people is people have to work when they go to SafeP. You can't just go down there and half-ass it. You understand? So are you going to do that? Or are you going to go down there and try to change your life and stay out of the court system and stay out of jail? Or are you going to go down there thinking that that's the quickest way back to your family?
No, I'm gonna go down there and actually try.
All right. Because it's not the quickest way back to your family. The quickest way back to your family is to go to prison and be done with it.
I know.
But that doesn't help you with your drug addiction when you get out. And it doesn't give you the tools that you need to avoid another conviction and another stint in prison. Okay. So I just want to make sure that we're clear with each other. Are we?
Yes.
Okay. All right. And so, Ms. Delaney, this is the decision you're making today, intentionally, knowingly, and voluntarily. Is that correct?
Yes.
All right. Anything further, Mr. Manning?
Judge, as she referenced, part of the difficulty here is that she did have expectations one way, and those expectations unfortunately were not met. However, that was also coupled with something that she recently informed me today, is that both her parents are experiencing health problems. That's what she's referencing, is that she had set up to leave today to prepare a place for them, to take care of them, as well as to try to maintain her sobriety. And so with that not happening, I think that is a bitter blow, but I have also talked to her about the benefits of SafeP and how long-term I think this is going to benefit her in her journey of sobriety, as well as her journey to avoid any further interactions with the criminal justice system.
Thank you, Mr. Manning. You know what that reminds me of, Lindy, is that, yeah, have you flown on an airplane? Have you been on an airplane before? What do the flight attendants tell you if you hit turbulence and the oxygen masks fall? What do they tell you?
I don't remember, honestly.
Say again?
I don't remember, honestly.
All right. Well, if you have someone next to you, they don't tell you to put their mask on and tend to them. The first thing they do is tell you to put your own mask on so that you can get oxygen, so that you can survive and that you can be help to those around you. So it's a noble thing wanting to take care of your parents. All right. That's a very noble thing. Unfortunately, at this time, if you don't put that oxygen mask on you and go to SafeP and try to get ahead of your addiction, then you're not going to be available to help your parents when they may need it even more.
Right.
Does that make sense?
Yes, sir.
All right. So you got to take care of yourself before you can take care of other people. All right. So I commend you for wanting to do that. But when you get out, you'll be a much better daughter in position to be able to do it for much longer. All right. Court approves the state's motion to withdraw and amend the conditions of community supervision for Ms. Delaney. Court orders her to attend the substance abuse felony punishment facility known as SafeP, and the court amends her conditions to include attorney fees and court costs. All right, so Ms. Delaney, some people I tell good luck, especially when they're going to prison, because sometimes they might have to have luck of circumstances. But oftentimes when I tell people when it's time to go to safety, I don't say good luck because it's not about luck. I say it's time to go to work. All right, it's time to put forth the effort and be different. All right, and so I'm not telling you good luck. I'm telling you to go to work. All right,
Thank you.
you're welcome.
Judge, I believe that concludes the case that I have on this docket. May I be excused?
Yes, thank you, Mr. Manning. Appreciate you today.
Thank you, Judge.
Tell the DA to stay there. Okay?
Wait just a moment.
No, I'm gone.
Yeah, if they'll stay there so they can sign off on it.
Oh, Mr. Hartwell, can y'all stay at the courthouse until we bring the papers over?
Yeah.
Okay, thank you, sir.
I'll keep an eye on him. I'll make sure he doesn't step away.
We gotta keep an eye on you.
Well, I'm already gone.
You have to sign too.
This is AI. I'm at the house right now. This is all AI. I pre-programmed.
He's interested in artificial intelligence.
That's the only kind I know.
Figure out how to get that off Facebook.
Contact.
All right, for the record, cause number CR 22166, State of Texas versus Monty Travis Austin. Mr. Austin was set for motion to adjudicate. Mr. Austin failed to appear at 9 a.m. this morning as ordered. It is now 3:45 p.m. He has still not made an appearance. Court hereby issues a judgment nisi and alias capias. Court finding that Mr. Mr. Austin was out on $25,000 surety bond, finds that that's insufficient, and the court is going to issue new bail in the amount of $150,000. Court is going to have his name called loudly, distinctly 3 times. All right, that concludes this afternoon's criminal docket. Court is adjourned for the day.